necessarily in front of older adults.
That's true that the victims in this case were an age range of 8 to 15.
State of New York versus Andres A. You may proceed.
May it please the court, my name is Naomi Weinstein and I represent appellant Andres A. in this appeal. Your Honors, with my limited time, I would like to focus on the second part of Mr. A's argument, that the state failed to prove by clear and convincing evidence that Mr. A is a dangerous sex offender requiring confinement. In fact, what the evidence did show is that Mr. A does not have an inability to control his sex offending behavior. He participated in sex offender treatment while in prison. He voluntarily chose to continue that treatment in the custody of OMH after this Article 10 petition was filed. He's been medication compliant.
But that's what, yeah, he is in custody, which is why he's medication compliant. That is the problem, that when he is not in custody, he falls off his medication, decompensates, and attacks women.
So, Your Honor, I'm not excusing Mr. A's past criminal behavior or his behavior in the community. However, as Dr. Fraser, Mr. A's expert, credibly testified, and as the state's own expert admitted, cyst itself is different than what he had been subject to. He cannot go back to a shelter like he had been before with no supervision. Cyst itself is a protective measure against risk.
Was that an option for the court? Was the court under the statute permitted to have him go into a cyst program? I mean, it seems like maybe the statute has to be changed, but I don't think that was an option for the court to order that.
So when I think, Your Honor, if I could just, to answer your question, I believe that there might have been some confusion with the court as to what Mr. A's expert was recommending. What Mr. A's expert was recommending was community-based supportive housing, which the state's own expert testified does exist specifically in the world of—
Yes, but he needs something much stricter than just community-based. I mean, come on. Every time he has been let out within months, he attacks someone else. Okay, so he clearly needs strict supervision.
And that's correct, Your Honor, and that is what is available. Cyst itself is very, as this court has stated in Enrique T., is very restrictive. It's not the same as probation or parole. He would be subject to 76 conditions that can be specifically tailored. And where the trial court erred is that the trial court had a responsibility per 1007F to consider the conditions of cyst. And when the state, like here, fails to prove that Mr. A has an inability to control sex offending behavior, which means there has to be some evidence that he's—
But they did present evidence that the state's experts did say he has an issue with impulsivity, with his ability to control his sexual desires and how he acts upon them, right?
The state
did say that. The expert did establish that.
The state's expert was testifying primarily on the underlying facts of the crime, which, as the Court of Appeals said in Donald D.D., the underlying facts of crime or crimes itself cannot form the basis. What the court has further clarified— I'm sorry.
I'm sorry. I was under the impression that it wasn't the underlying crimes, but the very disabilities that were confronted with.
Precisely.
He had an IQ of 50, I think.
Of 50?
And 50?
55, Your Honor.
Okay. So, and it was a combination of that and his poor impulse control, all those factors that created a real problem for him outside, correct?
So respectfully, Your Honor, his intellectual disability and his diagnoses, that goes to the first prong of mental abnormality, which we're also arguing the state failed to prove by clear and convincing evidence. But what the appellate court and the Court of Appeals has further clarified is that in order to show the higher level of inability, to prove that second prong, which is the focus of my argument before you today, they have to show that he's presently unable, and that comes from George N., that he's presently unable. And as Mr. A's expert credibly testified to, even when he's incarcerated, you would expect to see some sort of proxy behavior, some sort of misbehavior. Mr. A has not had any disciplinary tickets. He has never acted out sexually whatsoever since the incident.
But isn't it a fact that he acts out in front of young children, not necessarily in front of older adults?
That's true that the victims in this case were an age range of 8 to 15. However, as Dr. Fraser, who has extensive experience working with sex offenders, both who have intellectual disabilities and mental illness, she explained what proxy behavior you would see and what she does see in her work, which is that even when there's not maybe children or adolescents, you see behavior like grooming behavior. You see an attempt to
but
watch
there's
TV
no
with
one
children.
to groom. So again, in this, these observations are really difficult because they are in this very structured environment, right? So we're not evaluating these individuals in the community where you'd like us to place him, right? It's a different assessment. And again, based on Dennis K., it seems to me that the state put forward sufficient basis for two different diagnoses of your client that would suffice to establish his dangerousness and the propriety of civil commitment. I'll let you respond.
Thank you, Your Honor. I see my time is up. I would just respond respectfully, Your Honor. Dennis K. goes to the mental abnormality, which is the first prong that the state has to prove, and does not speak to whether he has an inability to control his sex offending behavior.
But no, Dennis K. talks about all of it. It doesn't just talk about that. It lays out what are the criteria. It can't just be ASPD. It has to have an additional finding, but then they go on to discuss the other issues. So it doesn't just talk about that, but I'll let you talk about that when you get back, and I'll give you a little extra time, all right? I'll hear you.
Good afternoon, and may it please the court. Anaga Sundarajan for the state of New York. Supreme Court correctly concluded that Andres A. suffers from a mental abnormality, and that based on the undisputed evidence at the dispositional hearing, concluded that Andres A. is a dangerous sex offender requiring confinement.
Now, perhaps I was a little confused in reading the record and the statutes, but what was the problem with the cyst regimen? The court did not have the right under the statute to require that. That seems to be like a little bit of an in-between place, not letting him out, but not having completely confined. So how do you get to the cyst program?
Sure, Your Honor. So a couple of responses to that. The first is getting there is part two of the court's inquiry. Here, there was ample evidence to support the court's conclusion that he met the requisite level of dangerousness and therefore under the statute required confinement. And I'll return to that in a moment. With respect to Your Honor's question, both the statute and the statute as interpreted in Nelson D. make very clear that it doesn't allow for that intermediate. You either have to have confinement in a secure setting under OMH custody or treatment on an outpatient basis under DOC's custody. We can't have Article 10 does not allow for that intermediate kind of confined, but not really, in large part because the purpose of Article 10 is not only to provide treatment, but also to ensure the security of the community for offenders who are unable to control their behavior and who meet that level of dangerousness.
So had this individual been in a residential treatment program, would he be entitled to cyst?
So, to clarify, Your Honor, it is certainly possible that someone under Article 10 civil management who is out in the community on a cyst regimen can then be placed in a residential treatment program. The problem here, there are two problems here with what respondent's expert was asking the court to do. The first is, again, as we noted, he has already shown, the state has already carried its burden of showing that he meets a certain level of dangerousness and that he cannot be treated purely on an outpatient basis. Based on that evidence, the court correctly concluded that he meets that dangerousness threshold and so has to be placed in a secure facility. Additionally, what respondent's expert was asking for was a level of supervision that went above and beyond what is contemplated by SIST, and that is where we
But then
fall
what
into
you're
this.
because what I'm hearing you say, though, and it's troubling, right? What I'm hearing you say is, in part because this gentleman has an IQ that prevents him from fully understanding that he has to take this medication or he's going to decompensate. Are we saying that he will never get out of confinement?
No, you're
How
wrong.
does he establish that he has gotten insight? I mean, how does he do that from behind these walls in this setting?
So a couple different ways, and I would point this court to Dr. Hernandez's testimony during the dispositional hearing. While in secure confinement, he has had access to treatment that is not only about sex offender treatment, but helping him develop pro-social behavior, helping him develop coping mechanisms, helping him develop ways to interrupt and self-regulate his behavior. Now, while in secure confinement, he has the right to petition at any time for review, which includes a petition to review his mental abnormality finding as well as his placement. He also has a right to an annual review. So it is certainly possible that a year from now at his annual review or at another time, because he has had access to this treatment that is tailored to his specific disabilities and is being provided while at Stark, that he will be able to show that he's developed some kind of coping mechanism, some kind of progress in treatment. The problem here is none of that has happened yet. He has, while he understands what his triggers are, he has not demonstrated any kind of mechanism to avoid them while in the community. And these are triggers as simple as avoiding children who are out on the street going about their business.
Now, I know counsel focuses on the fact that the state's experts really just touched upon, I should really say, focused on the facts of the underlying case. But, you know, I have the transcript here, and it seems to me that it was based on an entire psychological portrait when you're talking about the diagnosis, the intellectual disabilities, coupled with lack of insight, you know, substance abuse that lowers the inhibitions. No?
That's correct, Your Honor. And we would also note
And testing and assessments.
That's correct, Your Honor. And we would also note that there was testimony additionally about his performance on various risk assessments, about his lack of treatment, about his prior performance on supervision, which was very poor. And this testimony about these factors that went into the state's experts' conclusions were all, the respondents' experts agreed to the underlying facts, as Supreme Court noted in its opinion. Now, while respondents' expert may have reached a different conclusion, that different conclusion, again, was based on the court imposing this intermediate step, or this intermediate kind of unsecure confinement that is not allowable under the statute. I'm happy to answer additional questions with the remainder of my time. If none,
So somebody who has this intellectual disability, that I agree with my colleague, Justice Manson Daniels. This is troubling because if he can't operate out in the community on his own by himself, then he's always going to need supervision. But would he be required to live in some type of residence? Because he can't medicate himself. He doesn't know how to read and write.
so again,
That has been his problem.
So again, we would point this court to Dr. Hernandez's testimony during the dispositional hearing, which contemplates the fact that with the kind of treatment that he is receiving at Stark, he may be able to develop strategies to deal with that, strategies to cope with his disability, and develop techniques to actually succeed in the community. Again, he's not there yet. Additionally, to the extent that is a concern, that's something that he has the right to revisit.
Are you aware of any state facilities that would permit someone like him with his history? Because people in our society who have these mental deficiencies have supportive housing in the community. But often that is a mixed sex housing, which could be problematic here. So is there any state facility that would be able to house him, that would accept him into housing? Or again, because I continue to harp on this, because it would not be right that because of his mental deficiency, he spends the rest of his life in confinement.
I'm not sure about that, Your Honor, and the record here is silent as to that. And again, this is something that can and often is revisited at either the annual review or the petition. At this stage, it has to be a secure facility given his lack of insight, his lack of coping mechanisms, and his inability to control his behavior, which is well demonstrated by this record.
Thank you.
Thank you, Your Honors.
Give you an extra minute. Okay.
Thank you, Your Honor. I wanted to start by saying that CIST is meant to be the default. That is clear in the legislature intent in 1001 of the statute. And CIST is not meant to be a one-size-fits-all. And where the trial court erred is failing per 1007 to consider the specific conditions of that Mr. A would need, contrary to what.
But again, so it goes back. I'm going to ask you the same question, right? So is there a facility that would accept someone with your client's history, okay? So, because in residential placements where you have co-ed population, they're not going to, I can't imagine any center that would assume the liability of having someone with his sexual crime history.
So respectfully, Your Honor, absolutely. It doesn't necessarily have to be a state-run facility, but as this court is aware from its appeal in Anthony R., Mr. R was living in a supportive residence that exists through OMH that the state's own expert, Dr. Hernandez, testifies does exist. So I understand that it could be problematic, but unfortunately there are people with intellectual disability and mental illness who do get entangled with the criminal, justice system, but that doesn't mean that he has an inability to control his behavior. What the record demonstrated is that he actually has made progress. He does understand the importance of staying away from substances, of staying away from children. He's able to follow directions, and Dr. Fraser credibly testified, and Dr. Hernandez agreed that he's never been subject to GPS monitoring. He's never been subject to scram monitoring that would monitor alcohol use. He's never had, the court could, for example, direct the level of housing that he would need. He's never had that he's been discharged to a shelter before. He could have, for example, a forensic case manager who could help him navigate the world because, as this court noted, it is difficult with his IQ and he's Spanish speaking only, and he's not able to read and write. So there are accommodations that need to be made in order for him to be on CIST, but that does not make him a dangerous sex offender who requires confinement. Thank you.
Thank you so much. Thank you both.